Our next speaker this morning is Kathy Klock. Kathy is from the Akerman firm in Florida. Kathy represents national and regional securities brokerage firms, clearing firms, and officers, employees, and independent contractors in customer disputes, regulatory inquiries and investigations, internal investigations, employment disputes, and recruiting litigation, and other disputes involving industry members. She also has a broad range of experience in business litigation, including complex litigation and employment disputes. Kathy has served on the faculty for training programs for FINRA and conducts compliance and legal presentations for broker-dealers and other financial service firms. Here this morning to tell us about some of the best practices in the supervision and surveillance of independent contractors is Kathy Klock.
Thank you. Good morning. The independent contractor model, I'm going to have to move forward here. The independent contractor model is a very successful business model in the securities industry. It enables broker-dealers to expand its registered representative base and product distribution base with relatively low overhead, and also enables reps to provide a full range of services and products while maintaining relative independence in their own business. But the business model also presents unique challenges and risks for the industry, for the broker-dealer. It would be regulatory risks, risks from customer claims, and risks from individuals who have never been customers of the firm and are complete strangers to the firm. This program will touch on some of the methods of managing that risk, including the pre-hire process, supervisory policies and procedures, surveillance policies and practices, and the importance of follow-up on any red flags or information that may be missing or steps missing in any of these processes. In March of this year, the Wall Street Journal reported that brokers with an undisclosed bankruptcy had higher than average rates of customer complaints and other red flags. Financial problems are a significant red flag in this business and something that has to be focused on from the pre-hire stage throughout the time a broker is with a firm. In addition to the pre-hire checks, firms should use the tools that are utilized in that process while the broker is with the firm, either as a general practice or specifically when questions or concerns arise about the broker's sales practices or any financial issues going on with the individual, such as a divorce. FINRA is also targeting brokers with a pattern of complaints in its 2014 exam program. In its priorities letter for this year's audits, FINRA announced that in addition to its continued concern about the suitability for retail customers of complex products, its 2014 exam will include a focus on recidivist brokers. That is, brokers who have a history of customer complaints or red flags. This is not a new concept in this industry. It was formerly referred to as a rogue broker program. I guess that rogue brokers is not a politically correct term anymore, so now they're referring to recidivist brokers. I will refer to them as rogue brokers because it rolls off the tongue a lot easier. The rogue brokers are on FINRA's radar screen. They've always been on FINRA's radar screen, and they need to be on your radar screen, particularly in the context of independent contractors. Last year, FINRA launched the high-risk broker initiative to identify what they consider to be rogue brokers and expedite investigations. FINRA has announced that in the 2014 examination process, they will expand the high-risk broker program and create a dedicated enforcement team to prosecute these cases. In addition, when FINRA examines a firm that hires rogue brokers or high-risk brokers, the examiners are going to review the due diligence that has been conducted by the firm before these brokers are hired and evaluate the adequacy of the firm's supervision of the brokers, including whether the brokers have been placed on heightened supervision based upon the patterns of past conduct. The examiners are also going to focus on these individuals' customer accounts. In the context of rogue brokers, the FINRA will also be focusing on brokers who have been hired from firms who have either been closed down by a regulator or who have been the subject of severe discipline, for the obvious reason that they may bring poor sales practices to their new firm. FINRA has adopted and using an analytics program to identify and monitor brokers who have moved from these problematic firms and the firms who hire them, and they are going to use a risk modeling system to prioritize their surveillance and conduct focused or accelerated examinations and enforcement efforts. So firms need to be proactive. If you have hired, just because a broker came from a firm that's had a disciplinary history or been closed down doesn't mean that the broker is a bad broker. However, it is a issue, it is raised as a red flag, and so if during the process you haven't documented a heightened review of the individual, to get ahead of this year's audit program or inspection program, I suggest that you go back and conduct and make sure your procedures provide for heightened either inspections or supervisions of these individuals for a period of time until the firm develops a level of comfort that this is an individual who just happened to be with a bad firm and doesn't happen to be a rogue broker himself. Oops, I passed it, sorry. If your firm has not already done so, you should adopt policies and procedures for a more comprehensive review of these brokers who come from prior firms. Anyone who's in the compliance side of the business or the legal side knows leopards do not change their spots. And any additional vetting may prevent a bad hire. The folks who are on the recruiting side of your business are in the sales business, and they are more prone to accept someone or want to hire someone to get their hiring numbers where they need to be. But the additional vetting that you do at the pre-hire stage is going to save you a lot of problems and headaches later on. So in addition, any additional pre-hire review that you do of a broker who comes from a quote-unquote rogue firm should be documented, because in the audit process, the FINRA and other regulators are going to be looking for that documentation, and if you've taken that extra steps, you certainly want to document it as well. And to the extent that the individual has had any prior customer complaints, there's a great benefit to your firm by putting together a special educational program to address issues with this individual and make sure that your firm's compliance approach to the business and is reinforced, and that certain sales or regulatory rules and your policies are reinforced with that individual. And again, document it, because it will go a long way if you end up with a regulatory or civil action. Your firm's good reputation is not going to change bad sales practices. If the broker has been exposed to bad practices, you may have to re-educate this individual or make a decision not to hire the individual. If a person has been poorly trained, that is something you can address. If the person is just a bad character, a bad player, you're not going to change that through education, and that's when you just have to make the decision to take a pass. The importance of branch exams was highlighted in the SEC's disciplinary action against Royal Alliance several years ago. This disciplinary action arose out of a one-man satellite office, but resulted in a $500,000 fine against the BD and a disgorgement order for $1 million. In that instance, the broker-dealer, procedures required the OSJ manager to conduct at least one exam each year of every satellite office and to complete a workbook following the exam. The manager actually conducted the review, but didn't complete all of the sections of the exam workbook. And the SEC found that the firm's failure to have a system to review the exam workbook was a failure to supervise, and that included whether all sections of the exam workbook had been completed. So in this case, the BD had also included in its exam workbook a requirement to include a review of the broker's bank records. And again, while the OSJ manager conducted the review, he did not document a review of the bank records and actually didn't do it. And so that was found, the supervisor's failure to conduct these and the firm's failure to detect that the supervisor had failed to conduct these aspects of the examination were found to be failures to supervise. But in addition to the regulatory exposure, which is an issue, the BD was also exposed to liability on customer claims. So if the manager's failure to have reviewed the broker's records had been detected and the firm had required the manager or some other supervisor to go back and review the broker's records, they would have seen that in the broker's bank account there were checks to and from customers. And that would have been, put the firm on notice that the broker was obviously stealing money from the customers or selling away or engaged in some conduct that's a violation of securities laws. So in addition to the fact that they failed in their supervisory obligations from a supervisory standpoint, they also exposed themselves to civil liability, which could have been avoided. So the takeaway from the Royal Alliance case is office inspections must be conducted in accordance with the firm's policies and procedures. The inspection report must be reviewed from a supervisory standpoint to ensure that all of the reviews that were required have been done, to ensure that all of the documentation that is required to have been gathered has been gathered, and to make sure that any follow-up that was needed is actually done through completion. I think that the burdens on supervisors and compliance departments are enormous in this climate. However, if you don't take these extra steps, the exposure can be significant because the fines are not what they used to be 10 years ago. The fines are significant and the customer complaints are endless. So, the surveillance of electronic correspondence is critically important from a risk management standpoint as well as to comply with regulatory requirements. This past year, a broker-dealer was fined $7.5 million in order to establish a $1.5 million fund for customers because of failures in its email surveillance system that prevented the firm from accessing and reviewing emails. The findings were that the firm's business had grown, but the firm had not devoted sufficient resources in order to improve and expand its surveillance system, and as a result, many millions of emails were not reviewed. In addition, the firm had an inability to access emails, and because of a conversion process, many emails were corrupted. And so I think the takeaway from this case is, as your firm grows and the email communications are so common, I don't know if your practice involves this, but I used to get so many phone calls in a day, and now the phone calls are limited, but the email account is about 300 emails a day. God forbid you step out of the office for 10 minutes, you just cleaned your email out and you have 40 more. And so that's what your brokers are communicating that way too. And that's even worse than the emails between counsel and clients because they don't seem to have a governor sometimes on what they say. So that is a very important area, and compliance resources are limited sometimes, but this is an area where the SEC has made it very, very clear that you will invest the resources to have appropriate email surveillance system. I want to talk a little bit now about the pre-hire and post-contract training. The pre-hire process is your first line of defense. As I indicated earlier, the personnel on the recruiting side are interested in bringing people on board. The personnel on the compliance side are making sure that the firm's risk is manageable. In the end, the lack of a robust pre-hire review will cost the firm money. And so in that process, our recommendations are that you review all customer complaints critically. Sometimes the broker will give an explanation that may seem plausible, but in many instances, it warrants a further review. I finished a regulatory matter late last year, which involved a customer complaint that alleged fraud, and the broker actually gave a plausible explanation, and the matter actually disappeared off of his CRD. We never figured out how that happened. But as things turned out, it probably was true that he committed fraud because history repeated itself. And so that issue, the broker's explanation was accepted. Probably if the firm had dove into it a little bit deeper, they probably would not have hired this person and saved themselves several $1 million in problems. So the review the prior customer complaints, follow up as appropriate and possible on any issues that are detected, review outside business activities, review their existing DBA websites, and review any regulatory matters that have come up. And then you should evaluate the supervisory requirements for any independent investment advisor business the broker is involved in. Again, I just want to touch on the post-onboard training. If you have anyone with specific issues, there's a lot of value to create a tailored program of some educational issues, some materials for the individual to read, and possibly to sit down with either a supervisor or a compliance personnel for 4 hours, 5 hours a day, give them some training and document it, and that can go a long way if there's a problem in the future. Your supervisory system must be tailored to the independent contractor model because it has unique issues. The supervisory system must take into account the nature of your customers and the broker's business, your firm's business, any heightened supervision that may be required based upon either the broker's personal history or the firm the broker came from, and whether the registered rep is in an OSJ or in a remote office. The supervisory system also needs to focus on any sales practice issues that have arisen out of the office. And of course, the supervisory system must be tailored to prevent violations, prevent and detect violations, and should include hiring, training on compliance policies and procedures, product training, heightened training for sales of complex products to retail customers, correspondence reviews, exception reports, and surveillance. And if sales practice violations or fraudulent conduct is suspected, follow through with investigation, internal discipline, and regulatory reporting if appropriate. I want to touch a little bit on the office inspection process. FINRA uses a risk-based system to select branches for examinations, and the primary factors that FINRA uses are the number of customer complaints, the amount of revenue generated by the location, the disciplinary history of the former BD of the individuals, as well as the disciplinary history of the individual, and the types of products. Your firm's inspection program should follow a similar analytic process. And other issues you have to look at is announced versus unannounced audits, frequency, and intervals. I handled a regulatory matter within the last couple of years where, although there were unannounced visits or inspections, the state regulator believed that the unannounced inspections should be more frequent. FINRA is grappling with these unannounced inspections itself because they can arrive at a remote office and the individual's not there. And that is a cost factor for a firm because if you have an unannounced visit, you may show up, your auditor may have flown in, rented a car, and nobody's at the office. However, that is not going to be a defense to a regulatory action because despite that cost, you're required to do unannounced visits on an appropriate frequency based on your business model. And I can tell you in this instance, there were unannounced visits, but it wasn't satisfactory. So you might want to increase your unannounced visits. Frequency, they should not be on regular intervals. They shouldn't be on an interval where an individual can predict when an auditor is going to show up or an examiner is going to show up. That you need that surprise element if you're going to detect unlawful conduct. The frequency, I strongly recommend, particularly if you've got someone who could be in the high-risk category, that you conduct inspections more frequently than your procedures require just from a prophylactic standpoint. And all of your inspection procedures must be documented, and again, it is so important that there is a second layer of review, so that someone's looking at these inspection reports, and if they see something hasn't been done or follow-up hasn't been conducted, that is taken care of, because again, you have to do that from a compliance or regulatory standpoint, and you also may avoid litigation risk as well. FINRA Regulatory Notice 1154 provides broker-dealers with information on developing effective policies and procedures for branch office inspections, and I would encourage you to look at that. I am going to move forward here, because this material is in your book. I just want to focus very quickly on education. I believe that education is one of the most important things that broker-dealers can do, and also for independent broker-dealers. And my recommendation is when you do your annual CLE programs, that you adopt programs which put the brokers in the hot seat. Mock arbitrations, mock on-the-record examinations, and for supervisors, mock on-the-record examinations of them. And if you actually show them what their conduct looks like in a regulatory environment or in an arbitration or in a jury trial, it is very, very effective, because brokers are salesmen. And they believe that, you know, what they're saying makes sense and it's okay, but if you show them what it looks like in the context of a regulatory investigation or litigation, it's very effective. I'm sure Larry's firm has conducted these programs. Our firm conducts the programs. And not only is it effective, sometimes the brokers get mad. How could that happen? How could this be viewed this way? But the important thing is it's effective. And it shows them what their conduct could result in, including the loss of their license, and that's something that is near and dear to all of them. So there's some resource materials in the program materials that I encourage you to take a look at, and I thank you very much for your time today.